Good morning, everyone, and welcome to today's webinar. My name is Chetan Singh Gill. I'll be the host for the session and helping every one of you to reach out to the knowledge that I would be delivering today. Today's webinar, which is organized by Chandigarh Judicial Academy, the webinar is on the restricted functioning of the courts and its challenges. The session would be taken care by Honorable Mrs. Justice Alka Sarin, ma'am, who's a judge at High Court of Punjab, Haryana. Now, before I pass on the baton, I'm sure every one of you have met ma'am or know ma'am. A quick introduction about what ma'am has achieved over the years. Ma'am was born in New Delhi on 21st of June 1966, and she graduated from Delhi University with a BA Honours degree in Political Science. She enrolled at the Campus Law Center, Delhi University, and obtained her LLB degree in 1990 with a first division. She initially practiced before Supreme Court of India and the Delhi High Court. While practicing at PNH High Court, Justice Alka Sarin ma'am obtained her LLM degree from Kurukshetra University in 2004. As a lawyer, ma'am has dealt with all types of civil litigation, including family disputes, land disputes, rent disputes, cases of medical negligence, arbitration disputes, taxation disputes, labor disputes, consumer and matrimonial disputes, etc. Apart from carrying out due diligence investigations. Justice Alka Sarin has given lectures, talk, presentations on medical legal issues relating to organ donations, law related to sexual harassment, child abuse, and women law. And today we have the pleasure of ma'am sharing the screen with us and giving her time. So without any further ado, I would request ma'am. First of all, I would thank ma'am for giving us time and joining us over here. And I would just request ma'am to pass on the baton to start the webinar. This webinar will be, ma'am has requested for one thing that ma'am would like to have it more like an interactive session. So if you have any questions, do not wait for the last section when we ask questions. You can ask your question during the webinar itself, what ma'am is talking about, and I will be, I will pick up those questions and raise it at the same time. And now, ma'am, I welcome you. I thank you first of all for giving your time. And ma'am, I request you to please start the session. Ma'am, over to you.
Thank you, Chetan. Morning, everyone. So our topic today we're going to discuss is the restricted functioning of the courts and its challenges. Extraordinary times call for extraordinary measures. What the world is facing today is absolutely unprecedented and unplanned. The COVID-19 pandemic took us all by surprise, and it has stretched and affected every sector, every sphere, be it the government, judiciary, healthcare, banking, insurance, police, and every household. However, nobody has given up, and we cannot shut shop. We have to continue to discharge our duties. The judiciary, like all other spheres and all other organizations, was faced with a huge challenge. Initially, when the curfew was imposed, the courts were shut down, suspended for a while. But judiciary being a very important pillar of a healthier democracy, we could not keep our doors shut for long. And in order to combat this phenomenal situation, certain extraordinary measures were required and were put in place so that we could continue dispensing justice. What I'm talking here is the birth of virtual courts, where we sit in front of our computers, laptop screens, interact with lawyers who are sitting in front of their own computers, not in a courtroom, but elsewhere. Initially, when this concept of virtual courts came up, there was also a kind of a debate which was going on as to what is the definition of a court. There were long debates which went on, and ultimately they said courts is a service, and hence we could hold court from anywhere else, and it's not a particular place. So then we moved on to virtual courts. Now, what do we require for setting up a virtual court without any physical interaction? We need a good enabled, internet enabled computer. We need with a webcam. We need a good software, high speed internet connection, a dedicated email. This has to be both at both ends, our end, at the end of the judiciary, as well as with the lawyers. Once these are in place, there should be no difficulty in hearing or deciding cases in virtual court. Let me just share with you how I am holding court for the last 1.5 years. I've been holding court primarily from my camp office at home. I don't have any staff member. I have not permitted any staff member to come home. And I operate the systems myself. My files come to my house and I handle the files myself. So how do we create this virtual group for the day? So once the list is out, my staff creates a WhatsApp group for the lawyers. And the lawyers send in their requests, whether it's for adjournments or the documents that they want to rely upon. We also have a dedicated email where the lawyers can send in their written arguments, any other documents that they want to refer to. By about 9 in the morning, my staff downloads it, prints them, and sends them to me at my residence. Now, I have also been hearing lengthy matters. What I do is, in very lengthy matters, I normally will ask the lawyers to send me a brief written submission, so that in case something is missed out because of connectivity issue, I can refer to the written argument so that nothing is missed out when I'm dictating an order. Even my orders, I dictate while sitting in virtual court. My secretary, who logs in from either his office or from the court, then sends the dictated orders to me on email. I correct them on email, and then the physical copies are sent to me for signing. So you see, the whole process is being done virtually, and I'm not a computer savvy person. So when this is so simple, why are we not at the same level? Why aren't we just being able to dispose of the same number of cases that we were doing prior to the pandemic? See, I was given a list by the High Court of the virtual courts which are functional in the districts. In Haryana, Hisar has done very well by setting up 16 regular virtual courts. So has Kaithal, Jhajjar, Faridabad, Ambala, Bhiwani, Sonipat, Sirsa, Narnaul, Panchkula, Panipat. In Punjab, Ludhiana has set up 60 virtual courts. These are 60 regular virtual courts. Barnala, Fazilka, Patiala has again got 40 virtual courts. Surprisingly, some of the bigger districts have 0 virtual courts, regular virtual courts. Off and on, they're doing work through virtual courts, but no regular virtual courts. Now one wants to understand as to what is the difficulty. You see, in physical mode, when we are working in physical mode, we're going to be able to do very restricted kind of work. One, we can't allow the same number of lawyers, same number of litigants to enter our courtrooms. Two, when we are going to be spacing out our work, it slows down. It slows down because we are allowing lawyers to come in, say groups of 4, 5. So it slows down everything and we're not able to dispose of. But sitting virtually, believe me, we can do a lot more work. With the numbers going down, we did go back to physical hearing. But again, with the second wave, full-fledged physical hearings became an impossibility. And now even if they're being held in a very restricted number of cases. So what is the way forward? Way forward is to go back to virtual courts and see how much work we can actually dispose of. We have to understand that the work is not getting reduced. It's only clogging our system, it's piling up. Tomorrow, we have to do this work. No one else is going to come and do this work. So, in the interest of the judiciary, in the interest of the general public, and it is in everybody's interest that we continue dispensing justice in the best way possible. I'll tell you, in the last 1.5 years that they've been working virtually, we worked physically for a very limited period of time in the High Court. Sitting virtually, practically most of the time, the High Court disposed of 67,485 cases out of the 102,683 cases which were filed, which is a huge number. And this was all done sitting virtually. So you see, if we move towards virtual courts, we will be able to do a lot more. As an administrative judge, my interaction with some of the judicial officers who I interacted with, they brought out the apprehensions which are being faced by them. One is, how do we hear lengthy arguments? How do we record evidence? How do we dictate orders? And of course, to top the list, I'm not computer savvy and cannot operate a computer. Coming to the last first, we don't need any technical knowledge to conduct a virtual court. 1 or 2 training sessions and we are good to go. Today, I think most of us are operating smartphones. If you can operate a smartphone, no reason why we can't operate a computer. The reality is that we have to discharge our duties and responsibilities. And this pandemic is not going anywhere in the near future. So we need to remove our mental blocks and accept that technology is the way forward. If you have the will to do something, we will be able to do it. The other aspects are like hearing arguments, recording evidence. I'm sure all of you have been sent and have gone through the model rules of video conferencing, which have been circulated to all the district and session judges. These are model rules of video conferencing, which have been circulated by the Honorable Supreme Court. And we have to follow them in the best manner possible. Where arguments are concerned, or where daily hearings of cases like bail matters, anticipatory bail matters, or any other matters, it is not difficult. Even where lengthy arguments are concerned, like I said, ask the lawyers to help you out by shortening their submissions and to give you written arguments, which you can refer to later on while dictating the order. Of course, I understand that there are limitations of internet connectivity. And that is something very essential for virtual courts. In the interiors, I do believe that it could be a problem because there are a lot of lawyers who may not be having access to internet facilities or who may not be having access to a laptop or a computer. But this can also be done from a phone. We have a lot of lawyers who, when we were having hybrid hearings, were in the court for physical hearings, and from there itself they were joining the WebEx software and also addressing the courts virtually. So if you have a smartphone, if you have a 4G connection, which I think most places now have, that also should not be an issue. The issue which may be very daunting is the recording of evidence. However, if you've all gone through the model rules sent by the Supreme Court, I don't need to go into it in detail, but I'll briefly touch upon it. Chapter 3 of the model rules lays down the procedure for application of appearance, evidence, and submission by video conferencing. In this chapter also, it is very categorically being laid down that written arguments and precedents, if any, can be sent to the official ID of the concerned court. Rule 8 of the model rules deals with examination of persons, and detailed procedure has been given therein. How the testimonies are to be recorded and how it is to be signed by the party disposing have also been laid down. The presiding officer can either digitally sign it or physically sign it and then send a scanned copy to the person deposing for the person to sign. The complete procedure is laid down. If you go through it, it's a fairly simple procedure and there should be no difficulty in following it. We as the judiciary, as well as the lawyers, these are two limbs. We have to work in tandem to make this a success. Our endeavor as partners is to dispose of and to deliver justice, speedy justice. The Supreme Court, as you all are aware, has been giving various directions, starting with the suo motu Civil Writ Petition 1 of 2020, where directions were given to decongest prisons. Then there were directions given extending limitation, which later on was actually disposed of when the cases came down. And now again, by a recent order, it has again been extended. The extension of limitation was not only confined to limitation period as in condonable cases, but even in non-condonable cases. It was said that it could be condoned. Even for doing an act like giving an arbitral award, the time was extended under the Arbitration Act, Section 29A, under the Negotiable Instruments Act. The only thing for which the period was not extended was the validity of a check, because that the Supreme Court said comes within the ambit or the jurisdiction of the RBI, and they left it to their wisdom. This has been done to ensure that our working is not hampered and we have seamless virtual court proceedings. Even to the extent that since courts were being held, we were doing virtual hearings, service of notice, summons, exchange of pleading documents were allowed by email, fax, or commonly used instant messaging services. If you go through that order, it's a detailed order. I can give you the details of that order if you would all like to go through it. It says if you want to send, say, the summons by WhatsApp, you have to simultaneously serve it by email and it would be considered as effective service. So we have to really, all these things have been provided for. We have been permitted by the Supreme Court to resort to all this, only to simplify the procedure and to ensure that we can carry on with our day-to-day work, working virtually. Our, in October sometime when the cases started coming down, our own High Court on 6/10/2020 had ordered that the councils, after taking their consent, we can ask the councils if they are agreeable to appear physically in criminal trials, matrimonial cases, compromise matters, MACT and 138, following all SOPs, of course. Again, with the rising numbers in January, a notification was sent to all districts and session judges that they have to reassess the situation prevailing in their districts and thereafter permit physical hearing. Then we were hit by the second wave, and again things were put in a quandary. And on 17/4/2021, another direction was given by this court to assess the situation and decide accordingly as to which matters are to be taken up and which category of cases are to be heard. Now, at this point of time, most of the courts are functioning in a very, very restricted manner. If we do physical hearing, the numbers of cases that we are able to do will always remain restricted. However, if we shift to virtual, we will be able to do and dispose of much more. So as you can all see, the situation is very fluid. We are also being warned of a third wave, although the numbers are coming down now. So we cannot take things for granted. We really cannot foresee as to how long this pandemic will go on. Now, another thing which was brought to my notice as an administrative judge was that besides internet connectivity issues, some lawyers are very hesitant to appear, especially the older lawyers, saying that, they can't appear, they're not comfortable. So what is the way out? Of course, it is for us to sit with the Bar Association members, try and convince them. It is in everybody's benefits. You see, a lot of the lawyers are also suffering because lack of work. There are lawyers who have lesser number of briefs and they're actually rendered briefless today. So for them to be able to also earn, it is essential that we keep our work going on, keeping all aspects in mind, primary being and the foremost being dispensation of justice. So we need to encourage the lawyers. And if we all do, it's like the High Court. When we shifted to virtual mode, the lawyers had no option but to appear. So if a particular lawyer is hesitant to appear, another lawyer will appear. Once you set the ball rolling, people will start joining the session. So what you need to do here is not be aggressive, but be firm. Give them one opportunity. If, say, on the first date they don't appear in the virtual court, give a shorter date. Tell them to come again. And gradually they will all start coming. It's just a matter, it's just the initial hesitation. Even we as judges were very hesitant as to how this whole system is going to work. But it's worked very well. It's worked wonderfully well. You can explain to the lawyers. You see, if you have a smartphone, the difficulty is that I've heard a lot of people say that if I have a phone in my hand, I can't really argue while holding my phone in the hand. Please, you don't have to hold the phone in your hand. You don't have to. You have a stand. You get stands for your smartphones. You put it on a stand. Even a judge can do that. If you don't have access to a computer or a laptop, you can just put your smartphone on a stand and do it. It's not rocket science. Really, it's not rocket science. It's a very simple, fairly easy procedure to follow, provided you're willing to do it. Now, in cases where we are doing also physical hearings, say in some districts, restrict the number of lawyers who are coming in. How do we restrict? What we were doing here is in the High Court, say at a time we were permitting only, say, the first lawyers appearing in the first 4 cases to come in. So at a time we had maybe just 4 or 5 lawyers in the courtroom. You have to have one person posted outside who will only allow those many lawyers to come in. Secondly, discourage more than 2 lawyers from appearing in a particular case. You have both sides. At max, they can have one more lawyer with them, but not a battery of lawyers. Some of the senior lawyers, may have a battery of lawyers. That is not required. You have one briefing counsel, one other counsel, one assisting counsel. That is more than enough. So you have to lay down the rules for conducting the court as you think best. Now, I understand also that holding virtual court is a little more tedious than holding physical court. On days when we were doing till the second wave actually hit us, we had reached and we were doing about 50, 60 cases a day. And by the end of the day, we did feel more exhausted than we were when we were doing, hearing in physical mode. But that is more to do with the strain on the eyes, the screen time, and also straining our ears most of the time. Can't hear the lawyer. Sometimes we are trying to make ourselves understand. But in the end, it works out. It works out. It may take a little bit of toll on you by the end of the day, but things work out. Well, the downside is, do we have an option? Today, we don't. So if we don't have an option, what do we do? As a judiciary, our topmost priority is dispensation of justice. So, and especially in the second wave, the first wave was not so deadly. We've all seen how deadly the second wave is. So, my suggestion to all of you is try and make virtual hearings a possibility and a reality. And you will be able to see the disposal go up. So let's be all a little more open-minded. And till we can go back to full-scale physical hearing of court, or even hybrid. If you've all been following SCC online and live law and all these platforms, you must be reading. Some of the high courts have been hearing cases till late at night. They've been hearing lengthy matters. The Honorable Supreme Court has been hearing very lengthy and contentious matters. So there is no reason why courts at the district level cannot do the same. It is something which is not acceptable to me. If you say that, oh, we have to hear very lengthy arguments, we can't do it, sorry, it's not acceptable. Even yesterday, I think till about 12 o'clock, one of the benches in the Bombay High Court was sitting. This was the second time it sat for straight 12 hours and disposed of. In the last sitting I was reading, it had disposed of 80 cases. Yesterday it sat also again till 12 o'clock. So these are the kind of extraordinary efforts we will need to put in to meet this extraordinary situation. So what are the kind of cases that, besides the urgent, say, bail matters, anticipatory bail matters, what are the cases that one can do? My suggestion is sieve out the cases where evidence is complete, be it matrimonial cases, be it MACT cases, be it 138 cases, objections against arbitral awards, which are ripe for arguments. Get them pulled out. Besides doing those matters, try and encourage the lawyers to also address arguments in these matters. Here, your spade work is all done. Your trial is over. It's now just for arguments. Hear them out and finish it. The other thing which we can do is I was told a lot of the mediation centers have shut down. We need to keep them going. We need to keep the mediation centers going. We can do it virtually. There's no difficulty. We don't need to physically sit with the parties to be able to get them to come to a compromise. Especially in matrimonial cases, we need to keep the mediation on. We can try and send these matrimonial cases where there is a possibility of a compromise and where compromise has not been tried, send those cases there. MACT cases, I am noticing in the first appeals that are coming for us that the insurance companies are now very keen to actually settle the matters because they end up paying lesser amounts as interest. So see where things can be worked out. See, it's a very straightforward format now. The Supreme Court has laid down under all heads how much is to be paid. What I have done is I have culled out a chart. Under this head, this much is to be paid. Under this head, this much is to be paid. Once you have that chart, there's very little scope. You have to see, yes, there has been an accident. Yes, negligence is made out. And driver had a valid driving license and all those questions. Where the compensation is concerned, it's pretty much fixed by the judgments of the Honorable Supreme Court. So draw up that chart and it will make your things so much easier for you to decide. That's how I decide the cases. That chart is lying on my table when I'm dealing with a MACT matter, and I just go by the chart. So really to sum up, I would say that all of you are very, very capable officers and you're making tremendous efforts in dispensing justice, even in these very trying and difficult times. I'm also aware that so many of you have already been exposed to COVID-19 and keeping your own safety in mind and also the fact that we need to do our work, we need to discharge our duties, to dispense justice. I want to urge you all to make an endeavor and move towards virtual courts. Try and restrict physical hearing for the safety of the lawyers as well as your own. And if any of you, don't hesitate. If you feel there are any technical difficulties, if you have any difficulty in understanding, operating a system, don't hesitate. Approach your district judge. And I'm sure just a very short course, 2 days, maximum 2 days, and you will be good to go. So those can be organized for you. Once we have the systems in place, it will be very easy for you all to operate. So wishing you all the best, and I'd be happy to take whatever questions any of you have, or any other challenges that you're facing. We can.
Thank you so much, ma'am. But yes, I think I completely agree, and I might be saying on everyone's behalf that yes, it's a new thing. It's a new step towards technology for all of us. But yet, we cannot shy away from this, and we need to accept it as soon as possible. Ma'am, I've been talking to a lot of, while I'm waiting for the question answer, I'd just like to share one thing. I've been getting a lot of calls from judicial officers. I'll take an example of this webinar because I can't comment and I should not comment on the working of the courts. But even for these webinars, it's also like a virtual court, but we're not dealing in a court matter, but in a webinar. And I think a lot of times we get a call from judicial officers, and I think members would agree on this part that the first time that they tried joining this webinar, they would have had a lot of challenges. But I think now this is the 20th or 21st webinar that we're having today. Over the period of time, members have now known that, okay, only have to click on this and the entire thing comes up. And I think, ma'am, system officers are doing, are coming, for help, because system officers have been, dealing with all this tech throughout their education period and even when they were in the courts. So I think system officers are also being a big help in helping all the judicial officers, overcoming this challenge. We're waiting for. I would request members. If you have any specific queries, anything concerning that that ma'am can answer it. Anything that you would like to share, as in that how you could overcome. What are the new things that like ma'am shared that ma'am has a chart which she takes care of, and ma'am did mention that you can have a mobile phone just to like. Even when I talk, I know that the hand movement plays a very important role in expressing myself. So if I'm holding a phone in one hand, it might just hamper my thought, my clarity of thought, or my my thoughts would not go in the same way. So if any one of you has added any a new thing to your functioning that has worked for you, please come forward and you can share it.
Officers from Ludhiana, if they can tell us, there's 60 courts functioning virtually. If they can share how they are recording evidence and how they are, going about their day-to-day functioning, it'd be very helpful for the other officers. And courts which have no virtual courts, regular virtual courts, I would also like to understand from them what are the difficulties they're facing. And please don't hesitate. Please tell us what are your problems so that we can solve it for you.
And in case members, anyone who would like to come online right now and would talk to like face to face, I do have an option now. Earlier it was not an option, so you can put your name, put your question in the chat, and if you want to come online, I will send you a link. You can join that link, and you can come face to face, and you can simply talk to ma'am directly. Ma'am, I have one question, sort of a question, or I would say a question or a statement. Mukesh, Seni sir has said that sometimes some advocates are adamant to give them a physical hearing. I think you did talk about that, but the question is still remains the same: that how do we tackle them?
You see, if we have, before the second wave, we did have that option of giving them a physical hearing. But right now, when we are working in such a restricted manner, it is not going to be possible. And we really need to talk them into it. We can be firm, but yet we can be politely explaining to them that, look, it is for the betterment, especially in cases where, say, the evidence is over and only the arguments are left. Where is the question of only being able to do it in a physical court? The judge has, as the officer, has the entire record. The lawyers have the record. Why can't they access it from their individual offices? So you need to explain to them. That is the only way we will be able to do, because of course we cannot function unless the lawyers agree. But then, like in where we are concerned, we do not give them a choice. When we were doing only virtual, there was no question. There would be some lawyers who would come up that please fix it in physical court. So you ask them the reason why they want it fixed in physical court. And if they say, oh, I will not be able to refer to my documents, then you reason it out with them as to what is the difficulty in referring to documents. You'll have to just tackle them, but we need to convince them.
I think it's also about, like you said, rightly said that, sometimes when they come up to you and say that, okay, I'm having this problem, maybe they don't have a solution, and you might have a solution to it because you have gone through that phase yourself. And I think probably that's the only thing that is, stopping them from, coming to virtual court. I think there's another thing. I'm a psychology student, so I understand is that, we have this, once we are an adult, we take it becomes very embarrassing for us to ask people for basic things, because now this is considered as a basic understanding. Everyone can join in, and if one of us doesn't know how to do it, I think somewhere down the line, it is very embarrassing for us that, should I ask someone, and someone would think that, I can't even join now. I think if that's the case, I think members can directly talk to the judge privately. I think that's one thing. Otherwise, ma'am, online.
We need to change our mindset.
Yes.
That's all.
I think we all, like ma'am, I was talking to you, it's a black swan event. I think last year, I was not doing these webinars. I was not aware of it. I consider myself as a very techie person, but I learned this thing. And I think this was just a need of an hour. So I think, and I think it's rightly said by Jyoti Mehra ma'am in the next comment she has made. She said that we must educate lawyers as well as litigants to make more and more use of virtual hearing methods. Because I think the more we do it, it's better. And she has suggested that we can make use of DLSA departments,
That's right.
and they can help us and bring everyone on the same level as soon as possible. So I think DLSA can do the same work.
You see, what we can do is where they can really help out is also setting up, say, uh, areas in designated areas in the court premises where a lawyer who does not have access to a computer at home or is, say, not computer savvy or is not able to operate the system at home, then they can come and address arguments from whatever facility that you are able to provide. Say maybe set up 4, 5, 6 computers from where the lawyers can come and access the system and address their. We've done it here in the library. It's been done in the High Court library. So a lot of lawyers who do not have access at home, or say do not have designated courtroom, a separate room from where they can conduct virtual court, then come to the High Court library. That can be done.
Yes, that will actually take care of that that the comfort level that they have problem that how will I get connected. So there's someone over there who will help them with everything. All they have to do is be there. That's actually a good point, ma'am. Ma'am, there's a question that we do video conferencing. We do the video conferencing through that particular software. I believe that's a WebEx. The question is, can we also do the video? Can we also do the virtual hearing through WhatsApp video calls?
Yes, that is being permitted. That is being permitted. But what I would really suggest is that instead of an audio call, do a video call, so that we are sure as to who we are talking to. I normally, or even on WebEx, a lot of lawyers will not turn on their cameras. I always insist that please turn on your camera, so that at least we can see who we are talking to. Yeah. We can see who's addressing the arguments. Very important. So do a video call. That's fine.
I think that will ease up a lot of people's concern, because I think WhatsApp video call has been I think everyone is used to it.
In fact, on one single call now you can add up to 8 people. Earlier you could only do one person at a time. Now you can add up to 8 people on the WhatsApp video call. So easily you can add your both sides lawyers and you can hear a matter. No issues at all.
That's a surprise, because I was aware of it's only 4. Now you're telling me it's 8.
Okay.
Okay.
This was updated, I think, about a couple of months ago. Okay. Maybe 4, 5, 6 months ago, and they permitted 8 people. And in fact, earlier WhatsApp call was only through phone. So the WhatsApp call, when you accessed it on the computer, you could not make a call from there. But now from the computer also you can make a call.
Yeah, I've seen that recently. And it's both. It's audio and video both. You can do it.
That's right.
I think I've been using that lately. I think it's a recent update. Anyone? So I think ma'am, should we talk about this WhatsApp desktop version once?
Yes.
How, right? So I think anyone who is using WhatsApp, you can also use WhatsApp onto your laptop. And it's very simple. You can either download the application. It is available on MacBooks and on Windows machine as well. You can download the software. It is available in your, on the website of WhatsApp, or you can open the browser. You can say WhatsApp for web, open in Google, and you don't have to do anything. It'll just show you a QR code on the screen. Just open your WhatsApp, scan that code from WhatsApp, and you will have WhatsApp running onto your laptop as well. And once you open that chat box on the top right, you'll have an option to do an audio call and also do a video call. So I think the question of what ma'am you were saying, that holding the phone, I think this will take care of that. Yes. Thank you so much for bringing this. I've been using it, but I think it just completely stepped off my mind. But thank you, ma'am. Moving to the next one, ma'am. Some name has not been mentioned, but the person has passed his regards and said that thank you so much for addressing this issue. That's a need of an hour. Moving to the question, please allow the judges to obtain the internet connections of their choices, because at present we are having BSNL Wi-Fi with speed in kbps, and the government is paying more than rupees 1,500, whereas in less than 1,000 rupees, we can have a fiber connection of other companies which can solve the problem to great extent. So
for this, you will really have to approach your district judge. And if there is an issue, the district judge can always approach the administrative judge, and this can be resolved in no time. This is really, there's no difficulty. You can put it up. In fact, you can put it up immediately, or district judge will put it up to the administrative judge, and this will be taken care of.
ma'am, I would like to add over here, even the Supreme Court is using Airtel now. The Supreme Court library using is Airtel. So I think the changes are happening. It's only when we bring it to someone notice that, okay, this has been given to us, but it's not working out. So I think once that has been brought to notice.
Fiber connections definitely work much faster than your normal connections.
Now another question. Sorry, it's not a question, but I would like to suggest that if we introduce e-link monitors in the courts, it may help a lot. Regular monitors tire our eyes, thereby hampering our work, and even judgment-making power as a tired mind can never be accurate. However, e-link monitors tabs do not have that requisite radiation to trouble the minds and seriously affect our. So basically, someone is saying that the screen time, like you were saying, ma'am, that after 50 hearings, you feel more tired as compared to you would have in the physical hearings. So one suggestion is that can we move on to this e-link monitors?
You see, one can do a lot of things, but there are financial constraints. So if we look at, say, e-link monitors, we're looking at putting in e-link monitors for all the districts. It's not that we can put it up for one person. So the cost factor has to be factored in, and we have to see what is workable. So in the limited resources that we may have for whatever districts we have, allocations. So everything has to be worked out within that framework. And till then, I mean, it's not. The thing is, we always have two options. Either we can sit and cry about our problems and say, oh, the screen it tires me, it exhausts me. Or we can say, all right, I have no other option. I have to make do. This is my best option and work with it. So right now, actually, we have no option. So we have to make do with whatever is available with us. Of course, it's a suggestion. It's a good suggestion which can be put up. But again, like I said, this will have to go through the various committees, and they'll have to see the financial impact of the whole thing.
Ma'am, in my office, this thing was raised a couple of years back. If I may add, a suggestion, small suggestion over here, ma'am, related to e-link monitors. Ma'am, what my company has been doing, especially for the accounts department, because they all throughout the day they sit on the front of the computer. There are special screens which cost around, I think, 700 or 800 rupees, which can be lashed onto your existing screen. So it becomes an anti-glare screen. Because I think that what we are talking about is the glare which people get stressed out with. That's one way. And ma'am, please.
Chetan, a simpler, cheaper option is you get these anti-glare glasses all over the neck, and they're very cheap. They're 300 or 400 rupees.
Yeah.
Very smart. I mean, they don't look like anything which will not suit your face. You can actually check out how they look on your face also.
I think online the 3D thing that they've done now. Yes.
So
I think that's a cheaper one. So I think we need to understand that it's not the screen, it's the glare which is coming from the screen. So like you said, ma'am, you can wear anti-glare glasses and you're good to go. And if you have existing glasses, you can also get a coating done. So you don't even have to get new specs made. You can just go to your nearest spectacle shop and ask for an anti-glare coating, and it will take care of everything. So nothing needs to be changed.
Regular users of glasses, like you will know, because if you're driving at night, you need anti-glare glasses. So most of do get that coating done in any case.
Yes. And the simpler way of checking that is if you have it or not. If you put your specs towards the light, if it reflects a blue or a green color light or brown sometimes, it is coated by anti-glare. I never thought that we'll be talking about the specs in a webinar.
That's what I'm saying. We have to look for solutions.
Yes.
Problems are there. Problems are always there. They will always be there.
Yeah.
So we can't hamper our functioning because of problems. We have to look towards solutions. And that goes for everything. Everywhere we let us stop concentrating on our problems.
Mm.
Let's concentrate on what is the solution now. How do we move forward?
I think that's what we're doing, brainstorming and addressing that big fat elephant in the room and how can we just surpass it.
I'll tell
Ma'am,
you,
moving to
most of these big fact elements are only right here.
yeah,
Nowhere
it's all it's actually a virtual elephant. I'm moving to the next. I think Neeraj Goel, sir, who's very, very active in these webinars. I think sir is saying the same thing, but I will just not ask his question, but read out his question. That biggest challenge before us is the network issues and willingness of advocates appearing before the virtual courts. I think you have already answered that question, ma'am. That we need to be firm and not aggressive on that front, and give shorter dates so that they can commit and ask them that what are the challenges that they're facing.
basically sit down with the bar association. You see, the complaint today that all the bar associations are making is that the lawyers are really suffering. They don't have, they're not getting an opportunity to appear in court and carry on with the work, and they are actually in financial, really, really facing financial hardships. So this is in their best interest also, and that is how you need to approach it. That our part, yes, we need to dispense justice. Your part also, if you come on board and we are able to work in tandem, we will be able to do much. So talk to the bar association members. I'm sure they're all very reasonable. Sit down with them, sit down virtually. I am not saying sit down over a cup of tea. Sit down virtually, have your meetings, and that's the only way forward.
Ma'am, coming to the fatigue factor, you did mention that that prior to compared to the physical hearing, this does take a toll on your health. And the question is about the same, that how can we tackle this pandemic fatigue and constant threat in our mind that our family members can get affected by the this disease, and then also manage the court working. Ma'am, what is it that you do to have that sane mind and still have energy to after the court hearings and days done?
So really, you have to also give yourself some downtime. So once you finish your work, you need to maybe go for a good walk, exercise at home, and see where the fears are concerned. Again, like I said, let's not concentrate, let's not, focus our energies on the problem. If these fears are there, they're very real, but we cannot live in fear. We cannot live in fear. So we have to look at the more positive side and say, all right, the fear is real. We will take our precautions and we have to move on. We can't just sit closed up in a room and spend our entire day thinking, oh, there is this virus waiting outside to catch us and we cannot step out. We can't do that. We can't do that. So downtime is my children are one is a lawyer and one is 21 years old. We still sit and play games in the evening. We play carom, we play Scrabble. So anything to de-stress you, anything to take your mind off all these things. That's what you need to do. See, we can't go out. We can't go out. Maybe you can play badminton, any sort of game, any sort of physical activity will actually take care of all your fatigue.
Exactly, ma'am. I read somewhere this thing that the universe works on vibrations. So the more you think about something, the stronger that thing will become. And in this scenario, the virus, the more you think about virus, you're making it more stronger and stronger because you're constantly thinking about it. So yes, I personally follow the same technique. I sit on computer for almost like 8-9 hours at a stretch, and then in the evening I have a fixed time that I would have to work out. So I sweat it out in the room, switch off the fans and all. And once I'm done with that, I think it just rejuvenates the entire, my.
Any downtime, and especially physical exercise, will
Yes.
totally rejuvenate you.
Ma'am, there's a same suggestion. I think that you've already talked about that, but it has another element. I'll just read out the question. Suggestion is that, ma'am, regards to poor litigants who do not have smartphones, one room in every court premises should be made with screen and number of every court so that there can be virtual appearance before the court. Now, the reason I'm reading out this question is because there's another challenge with this, that if we make a room for all these members, wouldn't there be a problem of the COVID-19 entries? Like anyone who is COVID-19 positive or has been, like have symptoms, they would not be able to, come into that room because of obvious reasons.
You see, instead of having it in the court complex itself, we can look at having some kind of a area, designated area, say maybe the Tehsil office or in any government offices, we can identify and set up these places there where people, one, do not have to travel and they can go there and access it. So those are things we can look at, or even the district, state legal aid authorities. They have their councils, and it's not difficult. I think most people, even I've seen rickshaw pullers today, they also have these, smartphones where they're all making video calls. They're all making video calls to their people at home. So maybe one or two, maybe a very small fraction of people do not have these video calls. Otherwise, I've seen my staff also. Everybody is doing video calls with their families back home. Yes, for people who do not have, provision can be made, or they can ask someone to help them. But provision definitely can be made in Tehsil offices or, panchayat offices or somewhere. That can be done.
I think it's all about, like you said, that focus should be shifted from the problem to solution.
Absolutely. It has to be that.
Yes. Ma'am, I think there's just an update. Someone, when I asked a question on behalf of someone that BSNL is slow and can be moved to another one, I've got an update from some members, from Neeraj Goyal sir, and someone name is not there. And the update is that this issue has already been resolved, and now members can go for. There's a specific budget that has been given by the state judiciaries, and you can now go and take your own personal landline depending on what works out for you. So I think members can still go. So the BSNL is not the only option. Thank you, Neil sir, for this update. Next question, ma'am, is from Jaswinder Singh sir, ADJ Gurdaspur. This is just to inform the officers that Honorable High Court has already. Okay, this is the same thing that there's a internet connection can be taken from any service provider. Let's take another one, ma'am. Juvenile should be done through video counseling. Ma'am, the question is about the juvenile, juvenile cases. Ma'am, the person, ma'am name is Surbhi Parashar. She's a principal magistrate, Juvenile Justice Board, Amritsar. The question is, in case of confession by juvenile, should it be done through video conferencing or in person? I think I know why, ma'am. She's saying that someone might be there who can be influencing that juvenile. And is it fine to issue production warrant for parents of juveniles, or should we mark their attendance through video conferencing?
You see, again, the difficulty is, of course, the child can be tutored, but then the nearest place where we can, you see, if we come to the video conferencing model rules, I'll tell you what this says, examination of persons. This is clause 8. So it says any person examined, including a witness, shall before being examined through video conferencing produce and file an identity proof. The affidavit will inter alia state that the person who is shown. So the person examined will ordinarily be examined during working hours. The oath will be administered to the person being examined by the coordinator at the court point. So you have where you are. So that is the court point, and the court person who is coordinating will administer the oath, and what they do, they have said is that you can appoint a person who will then be a coordinator at the other end, who will ensure that the child is not being tutored and the child is being independently examined, and that the testimony has to be countersigned by them. I can read that portion for you. It says the other side where the person is deposing is being referred to as the remote point. And they say that any document which is signed, say the witness is signing, who's deposing, it will also have to be countersigned by the person, the coordinator at the remote point. So we appoint a coordinator at the remote point, any reliable officer, and they can ensure that the child is not being tutored. But again, in case you feel that there is a chance, and without really endangering the child, we can call the child for and you are conducting physical hearing, you can call the child. It should not be a problem.
So I think this is all it's a personal call of the judicial officer, yes, that what needs to be done.
Yeah, to really see what is the benefit of the child. I mean, if the child has to travel for a long distance, which will actually end up exposing the child, you need to take a call.
Ma'am, another question, I think it's all related, but I think I will still pick up this question, considering that this has to be, I think, re-emphasized again and again. The question is asked in a different form now. It's not about the advocates, it's not about the litigant, it's about the jail staff. That, when the judicial officer or the lordship asks for a video conferencing and a person is in the jail staff takes 3 to 4 hours to get onto the video conferencing. So I think the only solution to that is that what you said, that they need to be trained.
They need to be trained. The directions need to be given out by the concerned district judges that if you're being called to court to appear before a virtual court, you have to join in immediately. Where is the question of delay? There is no question of delay. And you see, court timings are fixed. They know that today this matter is listed. They should be on call. They have to be on call. Yes. There's no reason why they should not be on call.
Ma'am, I don't know. Ma'am, please correct me if I'm wrong on this. I was wondering that yesterday you and I, we did a small testing yesterday, just to ensure that everything works out today in this webinar and there's no delay. Ma'am, is there anything such is happening for the jail staff and the court staff that testing can be done a day before with the system officers?
The procedure I'm following in my court is that once the WhatsApp group is created, it's created in the evening once the list comes. So everybody, all the lawyers given their appearances, I am appearing in so-and-so case, so-and-so case. In the morning, I log in at sharp 10. The lawyers log in, say, at about between 9:30 and quarter to 10. So they log in and the systems are checked. So it's like a dry run for them.
Right.
But once I log in, then things move smoothly. So really the court staff can ensure that all these people are present. And in WebEx, what I do is I don't permit anybody into the courtroom because the bandwidth then gets very drastically reduced and yes, there's a lot of disturbance. So all the participants are moved into the lobby, and the first 4 cases, 5 cases, whichever are in seriatim wise, those people are permitted entry into the courtroom. I also become the co-host so that suppose somebody unmutes themselves by mistake, it's not their case and they unmute and there's disturbance, we mute them. Yes. So these are things these are just procedures you need to put in place yourself. You need to tell your court staff, all right, these are the people who need to be here. These are the police officials who need to be here. Please inform them and make sure, create a WhatsApp group, make sure that they are all on in the lobby.
So I think yes, I think that does work out, because considering that like especially the co-host part, because if you're taking taking a code or working on a case, listening to a case, your co-host or other members can take care of the muting part and other things, so that the focus remains on the core case. Ma'am, there's another question. What is the approach to be taken towards recording of statement under section 164 during a pandemic situation? Should video call be considered as an option to recording the statement?
I don't see any reason why it cannot. This does not specifically refer to 164, but I don't see any reason why it cannot be done. If it is going to be proving difficult, you see, the thing is to record the 164 at the earliest. So video conferencing is definitely an option. But again, like I said, these are very difficult decisions to take. 164 again, where we are recording the statement of the victim. There can be chances of the victim being pressurized, like in a juvenile, the child being tutored. So we have to take a call. We have to assess the situation, and if you feel, again, the decision will have to be taken by you. If you feel that it can safely be done, then go ahead and do it. And if it cannot safely be done, and there are chances of some kind of pressure being put, then please ask for it to be recorded in physical mode.
Just an update about the internet. Mukesh Saini sir has just informed that for the internet, the amount which is approved or sanctioned by the court is 1,425 rupees. So anything that comes in that 1,400 rupees, you can take it, and otherwise you can contact Hon'ble Shri Ravi Inder Singh sir, who is I believe the OSD, and he will be able to give you information. So just wanted to add that, ma'am. And now I think this will be the last question, ma'am, related to juvenile cross-examination. Daisy ma'am is saying that lawyers are reluctant to cross-examine prosecution's witnesses on behalf of under trial accused or juvenile, as they want to consult accused before cross-examination, which is not possible virtually, and they insist on issuing production warrants for the juvenile or accused.
Yes, again, this has been answered. If you again go through the model code, this is again been answered somewhere. I had read it. Where the person being examined or the accused to be tried is in custody, the statement, or as the case may be, the testimony may be recorded through video conferencing. The court shall provide adequate opportunity to the under trial to consult in privacy with their counsel before. So, you see, there is no reason why the statement cannot be recorded. Maybe they can be given a phone and to consult their their lawyer in privacy. They can obviously do that. Yes. We can make that arrangement. But this is permitted, and this is a possibility. This is, if you want to refer to it, this is clause 8.3, which takes care of this situation.
I think that brings us to the end of the question answer round. I think one thing that has been done, that is that members have now been at least talking. They've been vocal, and I think a lot of questions which have been which were doubt. I think either members have answered this question, like Mukesh Saini sir answered the question of that the amount. Other things like you have mentioned that how to manage a court when there's a virtual hearing is happening, that you can have a co-host and you can open the you can put the members in lobby and all stuff. I think I was not expecting that it'll go beyond the scope of only law, but now we spoke about spectacles, we spoke about WhatsApp web, we spoke everything. So I think yes, what you were trying, what everyone we all were trying, that it should be interactive round and members should be able to get the answers. I think it has been achieved, or at least has been the work has started.
In fact, I would be very happy if after implementing, if they can send their feedbacks after about 15 days and let us know if they're facing any problems. The feedbacks can be sent back to me, and I will try and take it up on the administrative side with the other, my brother judges and sister judges, and bring it to their notice that these are the difficulties which are being faced and how we can best tackle them.
And I think one thing that you mentioned about Ludhiana courts, 60 virtual courts. So I couldn't really, I haven't heard anything from Ludhiana. Maybe might have heard, but the name was not there of the court. I think the best practice sharing is the way forward.
Absolutely. You see, they need to be in touch with each other. The district judges can all be in touch with each other. Courts like Ludhiana or Patiala or in Haryana, there are so many courts which have opened, operating a lot of virtual courts. Even smaller districts I've seen, like Mansa, Muksar Sahib, they all also have, regular virtual courts. So get in touch with them, find out how they're working, how their courts are functioning, and take it forward.
Exactly. I think that's the key, learning from today. Go forward. There's no way we don't have to stay there. We don't have to stay here. And the only way to go to go ahead is to go forward, not really, go back or stay there. Thank you so much, ma'am, for your time and sharing all these learnings with us. Yeah, I think it was a great pleasure for me to have this interaction and be able to ask these questions to you. And thank you for sharing small, minute things that you've been doing in your courtroom. And I hope this all helps.
Thank you.
Like you said, ma'am, members should reach out and seek help from you or from the academy, from the DLSA or anyone.
They're always welcome. 15 days from today, let them implement it. All of you, please implement it. See if you're facing any difficulties. Try and resolve it with your district judges, respective district judges. If you're unable to, send your suggestions to us. Anonymous, if you feel that you don't want to disclose your name, send it. We'll try and see where the difficulties are coming and how we can best find a solution for them.
Thank you, ma'am. Ma'am, on behalf of Chennai Judicial Academy, on behalf of SCC Online, on behalf of all the judicial officers who joined in, and I would like to thank you so much for your time. Thank you so much for sharing the wisdom. And just for everyone's reference, this session was being recorded. So you'll have a link of this video on the YouTube and also on Chennai Judicial Academy page. So you can refer to that. And thanks to all the judicial officers, all the members who joined in, because without you, this session would have been a one-sided session. So that would have not made sense. Thank you to all the members. Thank you so much, ma'am. And I'll see you again. Thank you, ma'am. Take care. We'll end this session now.